The Constitution of the United States of America, 1789. Preamble. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for common defence, promote general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Article 1, Section 1. All legislative powers herein granted shall be vested in the Congress of the United States, which shall consist of a Senate and a House of Representatives. Section 2. The House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualifications requisite for the electors of most numerous branch of the state legislature. No person shall be a representative who shall not have attained to the age of 25 years and be 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state in which he shall be chosen. Representatives and direct taxes shall not be apportioned amongst the several states which may be included within this union, according to their respective numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed, 3/5 of all persons. The actual enumeration shall be made within 3 years after the first meeting of Congress of the United States, and within every subsequent term of 10 years, in such manner as they shall by law direct. The number of representatives shall not exceed 1 for every 30,000, but each state shall have at least one representative, and until such enumeration shall be made, the state of New Hampshire shall be entitled to choose 3, Massachusetts 8, Rhode Island and Providence Plantations 1, Connecticut 5, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, North Carolina 5, South Carolina 5, and Georgia 3. When vacancies happen in the representation from any state, the executive authority thereof shall issue writs of election to fill such vacancies. The House of Representatives shall choose their Speaker and other officers, and shall have their sole power of impeachment. Section 3. The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof for 6 years, and each senator shall have 1 vote. Immediately after they shall be assembled in consequence of the first election, and they shall be divided as equally as may be into 3 classes. The seats of the senators of the first class shall be vacated at the expiration of the second year, and the second class at the expiration of the fourth year, and the third class at the expiration of the sixth year, so that 1/3 may be chosen every second year. And if vacancies by resignation or otherwise during the recess of the legislature of any state, the executive thereof may make temporary appointments until the next meeting of the legislature, which shall then fill such vacancies. No person shall be a senator who shall not have attained the age of 30 years and be 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of the state for which he has been chosen, which he shall be chosen. The Vice President of the United States shall be President of the Senate, but shall have no vote unless they be equally divided. The Senate shall choose their officers, and the President pro tempore of absence of the Vice President, or shall exercise the office of President of the United States. The Senate shall have sole power and to try all impeachments, and sitting for that purpose they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without concurrence of 2/3 of the members present. Judgment in cases of impeachment shall not extend further than the removal from office or the disqualification to hold and enjoy an office of honour, trust or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment and punishment according to law. Section 4. The times, places and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, by the Congress, and at any time by law make or alter such regulations, except as the places of choosing senators. The Congress shall assemble at least one day every year, and such meeting shall be the first Monday in December, unless they by law shall appoint a different day. Section 5. Each house shall be the judge of elections, returns and qualifications of his own members, and a majority of each shall constitute a quorum to do business, but a smaller number may adjourn from day to day, and may be authorised to compel the attendance of absent members in such manner, and under such penalties as each house may provide. Each house may determine the rules of its proceedings, punish its members for disorderly behaviour, and with concurrence of 2/3 expel a member. Each house shall keep a journal of its proceedings, from time to time publish the same, expecting parts as may in their judgment require secrecy, and the yeas and nays of the member of each house on any question shall, at the desire of 1/5 of those present, be entered into the journal. Neither house during the session of Congress shall, without consent of the other, adjourn more than 3 days, nor to any other place than that in which the two houses shall be sitting. Section 6. The senators and representatives shall receive a compensation for their services, to be ascertained by law and paid out for the Treasury of the United States. They shall, in all cases, except treason, felony, and breach of the peace, be privileged from arrest during their attendance at the session of their respective houses and in going to and returning from the same, and for any speech or debate in either house. They shall not be questioned in any other place. No senator or representative shall, during the time of which it is elected to be appointed as a civil officer under the authority of the United States, shall have been created, for the emoluments whereof shall have been increased during such time, and no person holding any office under the United States shall be a member of either house during the continuance in office. Section 7. All bills for raising revenue shall originate in the House of Representatives, but the Senate may produce or concur with amendments as on other bills. Every bill which shall have passed the House of Representatives and the Senate shall, before it become law, be presented to the President of the United States. If he approve, he shall sign, but if not, he shall return it with his objections to that house which it shall have originated. Who shall enter the objections at large on their journal and proceed to reconsider it. If after such reconsideration 2/3 of the House shall agree to pass the bill, it shall be sent together with the objections to the other House, by which it shall be likewise be reconsidered, and if approved by 2/3 of that House, it shall become law. But in such cases, the votes of the both houses shall be determined by yeas and nays, and the names of the persons voting for and against the bill shall be entered on the journal for each house respectively. If any bill shall not be returned by the President within 10 days, Sundays excepted, after it shall have been presented to him, the same shall be a law, like the manner in which he had signed it, unless the Congress, by their adjournment, prevent its return, in which case it shall not be a law. Every order, resolution, or vote to which the concurrence of the Senate and the House of Representatives may necessarily, except on question of adjournment, shall be presented to the President of the United States, and before the same shall take the effect, shall be approved by him or disapproved by him, shall be repassed by 2/3 of the Senate of the House of Representatives, according to the rules and limitations prescribed by the case of a bill. Section 8. The Congress shall have power to lay and collect taxes, duties, imposts, excises and pay the debts and provide for the common defence of general welfare of the United States. But duties, imposts and excises shall be uniform throughout the state. To borrow money on credit of the United States, to regulate commerce in foreign nations and among several states with Indian tribes, to establish a uniform rule of naturalization and uniform laws on the subject of bankruptcy through the United States, to coin money, regulate thereof and of foreign coin and fix the standard of weights and measures, to provide for punishment of counterfeiting and securities of current coin of United States, to establish post office and post roads, to promote progress of science and useful arts by securing limited times to authors and inventors for exclusive rights to their respective writings and discoveries, to constitute tribunals inferior to the Supreme Court, to define and punish piracy and felonies committed on the high seas and offences against the law of nations, to declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water, to raise and support armies, but no appropriation of money to use that shall be a longer term than 2 years, to provide and maintain a navy, to make rules for the government and regulation of the land and naval forces, to provide for calling forth the militia, to execute laws on the Union and suppress insurrections and rebel invasions, to provide for organising armies, disciplining militia and for governing such part of them as may be employed in the service of the United States, reserving the states respectively the appointment of officers and authority of training the militia according to the discipline prescribed by Congress, to exercise exclusive legislation in all cases whatsoever, such district not exceeding 10 square miles, as may, by the cessation of particular states and the acceptance of Congress, become the seat of government of the United States and exercise like authority over all places purchased by the consent of the legislature of all states in which the same shall be for the erection of forts, magazines, arsenals, dockyards and needful buildings, and to make laws which shall be necessary for proper carrying into execution the foregoing powers and all the powers vested by this Constitution and Government of the United States, or any department or officer thereof. Chapter 9. The migration of importation of such persons as any of the states now existing shall think proper to admit, shall not be prohibited by Congress by the year prior to the year 1880, prior to the year 1880, but a tax on duty may be imposed on such importation not exceeding $10 for that person. The privilege of the writ of habeas corpus shall not be suspended unless when cases of rebellion or invasion of the public safety may require it. No bill of attainder or ex post facto law can be passed. No capitalisation or other direct tax shall be laid unless in proportion to census or enumeration herein before direct to be taken. No tax or duty shall be laid on articles exported from any state. No preference shall be given to by any regulation of commerce or revenue to the ports of one state over that of those of another, nor shall vessels bound to or from one state be obliged to enter, clear or pay duties to another. No money shall be drawn from the treasury but the consequence of appropriations made by law, and a regular statement and account of the receipts and the expenditures of all money shall be kept and published from time to time. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without consent of Congress, accept to any present emolument, office or title of any kind from any king, prince, or foreign state. No state shall enter into a treaty alliance or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, or make anything but gold and silver coin and a tender and payment of debts past any bill of attainder or any post de facto law or law impairing the obligation of contracts or grant title of nobility. No state shall, without the consent of Congress, lay any imposts or duties on imports or imports except what they may be absolutely necessary for executing its inspection laws and net produce to all duties and imposts laid by any state on imports or imports shall be for the use of Treasury and of the United States, and all such laws shall be subject to revision and control under the Congress. No state, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter under any agreement or compact with any other state or with a foreign power, or engage in war unless actually invaded in imminent danger, as will not admit of delay. Article 2, Section 1. The executive power shall be vested in the President of the United States of America. He shall hold his office during the term of 4 years, and together with the Vice President chosen from the same team, be elected as followed. Each state shall appoint in much manner as the legislature thereof may direct a number of electors in equal to the whole number of senators and representatives to which the state may be entitled for Congress. But the senator or representative of the person holding the trust of the profit under the United States shall be appointed the elector. The electors shall meet in their respective states and vote by ballot for two persons, of whom one is at least shall not be an inhabitant of the same state with themselves, and they shall make a list of all the persons voted for and the number of persons for each, which list they shall sign and certify, transmit, seal to the Senate of the Government of the United States. Directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and the House of Representatives, open the certificates and votes shall be counted. Then the person having the greatest number of votes shall be the President. If the number of votes be a majority, then the number of electors appointed, and if more than one have such a majority and the equal number of votes, then the House of Representatives shall immediately choose a ballot by one of them for the President. And if no person has the majority, then the highest list, then from the five highest on the list, the said House shall in like manner choose the President. But in choosing the President, the vote shall be taken by states, the representative from each state having one vote. A quorum for this person shall consist of a member of all members from 2/3 of the states and a majority of the states shall be necessary to a choice. In each case, after the choice of the President, the person having the greatest number of votes of the electors shall be the Vice President. There should be remaining two or more who have equal votes. The Senate shall choose from them by choosing the Vice President. The Congress may determine the time of choosing the electors and the day in which they shall give their votes, the day which they shall be the same throughout the United States. No person except a natural-born citizen or citizen of the United States at the time of adoption of the Constitution shall be eligible for the office of President. Neither shall any person be eligible to that office who shall not be attained the age of 35 years and be 14 years resident in the United States. In the case of removal of the President from office, or his death, resignation, or inability to discharge the powers and duties of said office, the same shall dissolve on the Vice President, and the Congress may provide the case of removal. Death, resignation, or inability involve the President and the Vice President, declaring what officer shall then act as President, and such officer shall act accordingly until disability be removed or a President shall be elected. The President shall be at stated times receive his service a compensation which shall neither be increased or diminished during the period in which he shall be elected, and he shall not receive within that period any emolument from the United States or any of them. Before he enter the execution of his office, he shall take the following oath and affirmation. I do solemnly swear or affirm that I faithfully execute the office of President of the United States and will do the best of my ability to preserve, protect and defend the Constitution of the United States. Section 2. The President shall be Commander-in-Chief of the Army and the Navy of the United States and of the militia of several states. When called into actual service of the United States, he may require the opinion in writing of the principal officer of each of the executive departments upon any subject relating to the duties of their respective officers. He shall have power to grant reprieves and pardons for offences against the United States, except cases of impeachment. He shall have power, and by the advice of and consent of the Senate, to make treaties provided 2/3 of the senators present concur, and he shall nominate and he shall nominate and with the advice and consent of the Senate shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think it proper in the President alone, in the courts of law, and the heads of departments. The President shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions that shall expire at the end of the next session. Section 3. He shall from time to time give the Congress information on the state of the Union and recommend it to their consideration such measures as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses or either of them in the case of disagreement between them with respect to the time of adjournment. He may adjourn them in such time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed, and shall commission all the officers of the United States. Section 4. The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment and conviction of treason, bribery, or high crimes and misdemeanors. Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court, and such inferior courts as the Congress may from time to time ordain and establish. Judges both of the Supreme and inferior courts shall hold their offices during good behaviour, and shall be at stated times receive their services a compensation which shall not be diminished during the continuance in office. Section 2. The judicial power shall extend to all cases in law and equity arising under the Constitution, the laws of the United States and the treaties made or which shall be made under their authority, to all cases affecting ambassadors, other public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States will be a party, to controversies between two or more states, between the state and the citizens of another state, being citizens of different states, between citizens of the same state claiming lands under grants of different states, and between the state or the citizens thereof and foreign states, citizens or subjects. In all cases affecting ambassadors, the public ministers and consuls in those in which the state shall be party, the Supreme Court shall have original jurisdiction in all other cases before mentioned. The Supreme Court shall have appellate jurisdiction both as to law and fact, and such exceptions under the regulations as Congress will make. The trial of all crimes, except cases of impeachment, shall be a jury, and such trial shall be held in the state where the said crimes have been committed, but not committed within any state. The trial shall be in such a place or places as the Congress may by law have directed. Section 3. Treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless the testimony of two witnesses to the same overt act or confession in open court. The Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood and forfeiture, except during the life of the person attained. Article 4, Section 1. Full faith and credit shall be given in each state to the public acts, records and judicial proceedings of every other state, and Congress may be general laws prescribe the manner in which acts, recorded proceedings shall be proved, and hence an effect thereof. Section 2. The citizen of each state shall be entitled to all the privileges and immunities of the citizens of several states. A person charged in any state with treason, felony or crime, who shall flee from justice and be found in another state, shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime. No person held to serve or labour in one state under the laws hence thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labour, but shall be delivered up to the claim of the party to whom that such service or labour may be due. Section 3. New states may be admitted by Congress into the Union, but no new state shall be formed or erected within the jurisdiction of another state, nor any state be formed by the jurisdiction of two states or more states, or parts of states, without the consent of the legislatures of the states concerned as well as the Congress. The Congress shall have power to dispose of or make all needful rules and regulations respecting the territory of other property belonging to the United States, and nothing in this Constitution shall be construed as a prejudice in the claims of the United States or any other particular state. Section 4. United States shall guarantee every state in this Union a republican form of government, and shall protect each of them against invasion and on application of legislature or the executive when legislature cannot be convened against domestic violence. Article 5. The Congress, wherever 2/3 or both houses shall deem it necessary, shall propose amendments to this Constitution on or application on the legislature of the amendments, which in either case shall be valid and to all intents and purposes part this Constitution when ratified by the legislatures of the 3 or 4 several states or conventions in 3 or 4 thereof, as one of the other mode of ratification may be proposed by the Congress, provided that no amendment may be made prior to the 188 181 to the year 1808, and shall in any manner affect the 1st and 4th clauses of the 9th section of the article, and that no state without consent shall be deprived of its equal suffrage in the Senate. All debts contracted and engagement entered into before the adoption of this Constitution shall be valid against the United States under this Constitution, under the Confederation. The Constitution and the laws of the United States shall be made in pursuance thereof of treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, and anything in the constitutional law of any state contrary to notwithstanding. The senators and representatives before mentioned, and the members of the several state legislatures, and the effective and judicial officers both of the United States and several states shall be bound by an oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any public office or public trust under the United States. The amendments to the American Constitution, the Bill of Rights Preamble. The conventions of a number of the states have, the time of their adopting the Constitution, expressed a desire in order to prevent misconstruction or abuse of its powers that further declaratory and restrictive clauses should be added, as extending the ground of public confidence in the government. This best ensure the beneficent ends of its institution. Resolved by the Senate and the House of Representatives of the United States of America in Congress assembled, 2/3 both houses concurring, that the following articles proposed to the legislature of the several states as amendments to the Constitution of the United States, or with articles ratified by 3/4 of the said legislature, and the valid and to all intents and purposes as part of the Constitution vis-a-vis articles. In addition, the amendment of the Constitution of the United States of America proposed by Congress and ratified by legislatures of several states, pursuant to the 5th article of the original Constitution. Amendment 1. Congress shall make no law respecting an establishment of religion or prohibiting free exercise thereof, or abridging the freedom of speech or of the press, or of the right for people to peacefully to assemble and to petition the government for redress of grievances. Amendment 2. A well-regulated militia being necessarily to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Amendment 3. No soldier in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in manner to be described by law. Amendment 4. The right of people to be secure in their persons, houses, papers and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. No person shall be held to answer for a capital or otherwise infamous crime unless on presentment of indictment by grand jury, except in case of rising on the land, in the land or naval forces or in the militia, where the actual service in time of war or public danger, or shall any person be subject to the same offence to be twice put in jeopardy of life or limb, not shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty or property without due process of law, nor shall provide property to be taken for public use without just compensation. Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial, but the impartial jury of the Senate and district within the crime shall be committed within the district will have been previously ascertained by law and be informed of the nature of and cause of the acquisition, to be confronted with the witnesses against him, to have compulsory process obtaining witness in his favour, and to have the assistance of counsel in his defence. Amendment number 7. In suits at common law, there are value of controversy exceeding $20. The right of trial by jury shall be preserved, and no fact trial by jury shall be otherwise re-examined in the court of the United States according to the rules of common law. Amendment 8. Excessive bail shall not be required, excessive fines imposed, nor cruel and or unusual punishment inflicted. Amendment 9. The enumeration of the Constitution of certain rights shall be construed to deny the disparage other retained by the people. Amendment 10. The powers not delegated to the United States by Constitution nor prohibited by it to the United States are reserved to the states respectively or to the people. Amendment number 11. The judicial power of the United States shall not be construed to extend to any suit or law or equity commenced, prosecuted against one of the United States by citizens of another state or by citizens or subjects of a foreign state.